उसमें बहुत सारी चीजें बाज़ मोहम्मद काकड़ वाले केस के अंदर हैं
जी।
पेज 970 पे पढ़िए, एज इट हैज बीन पॉइंटेड आउट, इसमें तो इन्होंने सपोर्ट किया है कि जो है जुरिस्डिक्शन को बढ़ाना हो, सप्लीमेंटल करना हो तो कर सकती है पार्लियामेंट।
वो रिपील हो गया ना 247 जो
नहीं, आप कौन सा कह रहे
हो
हैं?
गया, बट द जजमेंट इज देयर, सुप्रीम कोर्ट का अपना जजमेंट तो है ना, वो रिपील।
Hello, para 37 of Baz Muhammad Kakar. If I can just read this out, Article 247, Clause 7. As now
पेज
it's
कौन
been,
सा पढ़ने पेज?
well, this is the Constitution itself. This was prior to its repeal
नो,
by
बाज़-उम्मत काकड़ का पेज कौन सा?
the page 967, para 37.
Citation.
This is PLD 2012 Supreme Court 923. Para 37 at 967. This is one example of enlargement of jurisdiction of the Supreme Court in terms of Article 247, Clause 7, which read, my lord, neither the Supreme Court nor a High Court shall exercise any jurisdiction under the Constitution in relation to a tribal area unless Majlis-e-Shura, Parliament by law otherwise provides. And pursuant to this, an act was promulgated in 1973. And this was taken notice of by this honorable court in. My lord, that's one example. The other is, as your lordship mentioned, Article 185 of the Constitution.
185.3 is very
185, 2D and E.
2, 3, Sorry,
These are
D,
express authorizations by the
185
Constitution.
D, yes.
185, 2D and also E.
Right.
नहीं, ये पेज 970 पे सप्लीमेंटल पावर का भी जिक्र है, पेज 970 पे जो पैराग्राफ है ना, वो आप पढ़िए, वो डिटेल में है।
जी जी,
उसमें ये क्लैरिटी आ जाती है,
Mr.
as it has been pointed out here and above.
My question is that even for a minute, I mean just something that if we were to leave 55 for a minute, what is really I mean, it's a question of interpretation. What's really stopping us from interpreting 191 to mean that it actually is envisaging a law for practice and procedure? It is the enabling provision. Suppose if we go in that direction, what comes in our way? I mean, that sort of solves a lot of mystery also. It is saying that the Constitution is envisaging that the Constitution could provide for practice and procedure, some law could provide for practice and procedure, and the Supreme Court can its rules provide for procedure. Meaning by, one way of looking at it is, meaning by that the Constitution is saying that, yes, for the purposes of practice and procedure, there could be a law. So 191 could be read as an enabling provision. If that is read as an enabling provision, then it sort of solves.
my lord, with all due respect, in my opinion, it can't be read as an enabling provision. It is a limitation, and the limitation that it imposes on the Supreme Court's power is not limited to practice and procedure.
No, but
let me just finish. Supposing can the Supreme Court rules cannot say that in adjudicating our appeals regarding contractual issues, we will not take into account the contract.
My problem is that suppose there were no rules made by the Supreme Court. So how would we look at 191 then? And then there is a law, the word law is mentioned. Suppose it's a total green field, there's nothing in the... So then a law could be there to regulate the practice and procedure. If the Supreme Court decides not to make the rules for a minute, then the source could be law itself. So then to call it limiting would be not...
My lord, could it be provincial law also? The law will
considering that it relates to, I mean, that's another issue with entry 58, that what does relate to federation mean? So if it relates to federation, perhaps it's a federal law that we're talking about or not. That's another question that I want to ask.
The problem is, as I said, there is a structural limitation on the word law in Article 191. You can't read it. Shoresh Kashmiri's case, PLD 69, Supreme Court 14 said, law is very broad. But here you will not include provincial law. You will, in my humble opinion, you will not include ordinances because ordinances are executive acts. If you allow, if I can just finish this, if you allow ordinances and rules which are law to be read into law in Article 191, what happens to 175.3? judiciary has to be separate from the executive. How can you allow the executive to make rules for practice and procedure of the Supreme Court? So the law, the word law in 191 has inbuilt limitations. I concede that it will include Act of Parliament, but in certain limited circumstances. Only when entry 55's conditions are met.
So your answer to the issue is that you would come through 55, you would come up with a law relating to enhancement, which is explicitly provided, and in that law,
Yes.
you could then ancillary
By
provide
virtue
for
of entry
practice and
59.
procedure.
That's my reading.
That's the only way to
That's
get.
that's the only way you.
But then those provisions would relate to the enlargement part,
Yes.
not anything more than that.
Not anything, and that's why I say it's a very restricted power, my lord. Sorry.
In terms of you raised a very interesting way to look at this thing, but I think if we look at law as conferring an enabling jurisdiction, I think one issue with 191 is that we have on the same thing, namely the practice and procedure of the court, we have two law-making powers. One is the Supreme Court. It's a direct grant by the Constitution. And if law is read in an enabling sense, then Parliament also. So this creates a situation where on the same subject matter, if I may use that term, ordinarily the problem arises where on the same subject matter, the division in terms of law-making ability is between federation and the provinces, right? So to take a very simple example, entry 49 of the taxes on income other than agricultural income, right? So the subject matter is tax on income, and the Constitution splits it into two. Agricultural income goes to the provinces, this goes to the, and we have whole issues of trespass and this, that, and you know all of that. Here the interesting thing is that on the same subject matter, practice and procedure, you have the Constitution is giving a grant to the Supreme Court itself. If law is read as an enabling power in Article 191, then the same power is conferred on a separate branch, the legislative branch. So, in terms of the principle of separation of powers, how do we resolve, how would we resolve a conflict if law over there is to be read as an enabling power? In terms of legislative competence, the division between federation and provinces, we know all of that. But here, how would we draw the distinction? How would we resolve a conflict? So maybe, because speaking for myself, I am not too satisfied with the way you are identifying it with entry number 55. Seems to me that a more natural on your reading would be entry 58. But that would mean that it is not an enabling provision. It doesn't really, it allows them to restrict, otherwise the conflict between two separate branches, making something that is law on the same subject matter, how would that be resolved?
My lord, I will address that.
Yeah, I think that's an excellent question. You want to mull it over. We will reconvene after lunch or prayers. ठीक है? तो आप आधे घंटे में वापस आ जाते हैं.
आधे घंटे में ठीक है.
ठीक है, you can mull it over the question before you start. We don't want to cut you short and you start something it doesn't finish.
ठीक सर.
ठीक है.
ठीक है. I'm grateful जी. Grateful.
नाज़रीन, प्रैक्टिस एंड प्रोसीजर एक्ट पर सुप्रीम कोर्ट में समाअत जारी है. चीफ जस्टिस काजी फायज की सरबराही में 15